All right, in Chapter 9, Lawrence Sung argues it is ethical to patent or copyright genes, embryos, or their parts. He starts off saying the question is it ethical to patent or copyright genes, embryos, or their parts implicates the intellectual property rights established by the U.S. Congress. The chapter is going to address the applicability and the wisdom of according intellectual property rights in the form of such U.S. copyright and patent exclusivity to biological subject matter. As charged by the editors, his chapter is going to advance the contemporary debate by saying why it is ethical to copyright and patent genes, embryos, and their parts. Now, he says a bit about what intellectual property rights are, and has a surprising statement. The ugly truth, he says, is that intellectual property rights policy is largely unconcerned with whether an author or inventor obtains a reward for his or her work or invention. The crux, instead, is whether the government grant of intellectual property rights is an efficient tool for driving national creativity and innovation. So, a public policy rationale is the incentive to create or invent and the incentive to invest in the creativity and innovation that exclusivity supports. Importantly, he says that patent rights inherently foster innovation by demanding public disclosure of inventions in exchange for a temporary term of exclusivity. Especially with medical technology, compromise is needed. A compromising patent exclusivity in the face of the public wants and needs for novel medical prevention, diagnosis, and treatment seems like a compelling case. And he points out that a commonly less recognized, but perhaps more important public policy is the incentive to disclose that a copyright and patent law seeks to embody. When talking about ethics and morality, Sung says that the debate over intellectual property rights is often framed generally as the tragedy of the anti-commons, concerns over access to knowledge restrictions, and the propriety of the ownership of products of nature. Interestingly, Sung says that a successful patent application has to present an invention that satisfies several conditions for patentability, including utility or usefulness, novelty, and non-obviousness. He notes that one problem with making sense of the patent law compared to biologic inventions is the temporal distortion that occurs between the time patent claims are filed and the time the U.S. Patent and Trade Office or federal courts pass on the patentability or invalidity of those claims. A decade or more, he says, with biologic inventions can separate these two events. Now, think about the novelty requirement, that to receive patent protection, an invention must be novel. An invention, to be novel, has to not be anticipated by the prior art. And an invention is anticipated, Sung says, if a single prior art reference expressly or inherently discloses each and every limitation of the claimed invention. Now, what about the other condition besides novelty? In addition to novelty, an invention has to be non-obvious at the time of the invention to one of ordinary skill in the relevant art. Interestingly, he says that the court rejected an approach known as the TSM test, or the teaching, suggestion, or motivated test, under which a patent claim is proved obvious only if some motivation or suggestion to combine the prior art teachings can be found in the prior art, the nature of the problem, or the knowledge of a person having ordinary skill in the art. In any event, Sung says, the exclusivity of a copyright and patent is only as robust as the ability and willingness of the federal courts to enforce it. And he gives some funny examples showing that the U.S. government may exercise march-in rights to transfer licensed subject invention rights to others, where the subject invention has not been sufficiently exploited by the existing licensee within a reasonable amount of time. And at bottom, he says, it is not as easy as one might think to obtain a patent, and even if a patent is granted, a patent does not convey the strong legal effect that one might expect. In the section Genes, Embryos, and Their Parts, Sung notes that because the same term, gene patent, is often applied to very different things, technically speaking, the legal governance of this technology is at sea without some measure of precision in the communication of what's being addressed. He points out that a patent applicant must be able to teach the public about the invention by providing a reasonably clear answer to two fundamental questions. First, what is it? And second, what does it do? And with regard to traditional gene patents, the response would include disclosure of the full-length DNA sequence that encodes a complete protein in conjunction with information about the protein and its potential beneficial uses. Now, the Human Genome Project, he points out, embodied breakthrough technology that made it possible for scientists to obtain vast numbers of genomic fragments by automated isolation and purification to facilitate chemical formula descriptions without learning anything about their origin, fit, or function. Now, one of the historical curiosities of this is that the U.S. Patent and Trade Office established a moratorium on the examination of certain kinds of gene processing, expressed sequence tag, and single nucleotide polymorphism claims. And the U.S. Patent and Trade Office struggled with some attempts to reconcile the applicability of traditional generic principles of patent law to genetics. Don't be confused with the similarity of the words generic and genetics. Now, Section 101 is especially important in this part of the law, 35 U.S.C. Section 101. It includes the mandate for a patent applicant to articulate a specific, substantial, and credible utility. And by utility, they mean usefulness. How exactly is it going to be used? You don't just want to be claiming we're going to use it somehow, somewhere in the future. In fact, in the words of the U.S. Supreme Court about this utility or usefulness requirement, quote, "A patent is not a hunting license. It is not a reward for the search, but compensation for its successful conclusion." Sung talks about the importance of subject matter in patent eligibility. He notes that in the court case Diamond versus Chakrabarti, the U.S. Supreme Court held that patent-eligible subject matter included anything under the sun made by man. And this kind of opened things up to lots of people applying for patents for things that were biological products. And Sung thinks this led to a lot of productive innovation because investors could throw their money behind people who had new ideas in the hopes that they could make returns on their investment. Anyhow, in March of 2010, Judge Robert Sweet of the U.S. District Court in New York granted a summary judgment that invalidated 7 United States patents which related to two important genes, BRCA1, sometimes called BRCA1 and BRCA2, associated with breast cancer. And Sung talks a little bit about the rationale behind Judge Sweet's decision, but Sweet, he notes, abruptly dismissed any concerns over the impact of his own decision on the biotech industry as, oh, that's unfounded. It's not going to impact the biotech industry badly. Public reaction to this particular ruling was mixed. On the one hand, Sung notes that patient advocacy groups and medical practitioners thought that the decision of this Judge Sweet lent credence to the idea that patent exclusivity for medical prevention, diagnosis, and treatment has been based on some very tenuous distinctions from the public domain and other kinds of lawyer tricks. But on the other hand, for industry members and their patent attorneys, Judge Sweet's decision represented an indefensible departure from decades of precedent, as well as a significant undermining of established investment-backed expectations. So, precedent notwithstanding, only history will tell whether Judge Sweet was simply the first to say that the emperor has no clothes. It's a colorful quote. Okay, so what's a possible path forward? Well, Congress could get involved. Sung notes, the U.S. Congress has the power to exclude subject matter as it sees fit from copyright and patent exclusivity, including action based on a determination that it's somehow unethical to patent or copyright genes, embryos, or their parts. But if Congress gets involved like this, Sung thinks it could be dangerous. Sung quotes Abraham Lincoln, who talked about adding the fuel of interest to the fire of genius. Okay? And Sung notes that without the continued openness of Section 101 to biological patents and innovations, the essential combustion that Lincoln noted that drives the engine of innovation may become a thing of the past. Sung says that the true detriment of revising the patent eligibility standard now to exclude biological products of certain types would be the incalculable lost opportunity from potential innovators discouraged from invention and publicly disclosing their findings. Tinkering with Section 101, he says, in the hopes of crafting a standard that's generally applicable to past, present, and future technologies, however well-intentioned it may bring unforeseeable consequences, including the unfortunate chilling of future innovation. Sung is close to the conclusion when he writes, what intellectual property rights do facilitate, however, is the placement of knowledge of innovation in the public domain and the ability to use such technology freely following a temporary period of exclusivity.